This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 11, Statute Law. Statute law is different from contract law. Contract is a big area of your syllabus. Statute law is fundamental in terms of it's statute law, for instance, that has created the Companies Act. So the Companies Act 2006 to 2005 is a principal element of the way that a company is run, and it has to be run in accordance with the Companies Act. So that's statute law. Contract law is not written down. Contract law is just based on agreements between two or more people in contract who enter into an agreement to provide a service or to sell a good or to perform a duty. Then that would be contract law, and it's different from statute law. So statute law is what governs. These are the written down rules. These are passed by the government. The government, the House of Commons, the lower house in the Houses of Parliament, and above them the House of Lords. And statute has to pass through both of these houses in order that eventually it's put in front of the Queen and she signs it. And once she's signed it, it then becomes law. And that's what statute law is. And there's a procedure for passing statute law. The procedure, only Parliament can pass law, only Parliament can make law, only Parliament can repeal law. You can't change the law once it's been passed by Parliament. Only Parliament can do that. So then we've got the Green Paper. And the Green Paper is a suggestion. It's an idea. It's promoted by not fewer than 10 members of Parliament. And they write out this idea and say, we think it would be a good idea to have a piece of legislation in this particular area. And if there's enough support, then it will make progress, and we then get to the White Paper. And the White Paper is after the comments have been received on the Green Paper, then the White Paper will be a draft, the first draft of the new proposed legislation. And that's then available for inspection and for reading, and then we go on into first reading. And first reading is where the paper, this draft legislation, is presented to the first of the two Houses of Parliament. It may go first to the House of Commons, or equally it could go first to the House of Lords and then go back to the Commons. So it will be presented to the first House of Parliament. It's being introduced. This is the White Paper, this is the draft legislation, this is the purpose of the proposed legislation, this is what we want to see go through. So that's only a formal introduction of the White Paper to the Houses of Parliament. And then second reading, this is where a lot of activity takes place. This is where there's a full debate within the particular House of Parliament, whether it be the Commons or the Lords. This is a full debate about the merits of the proposed legislation and whether or not the wording is loose, whether the wording is vague, whether it's uncertain, whether it's ambiguous. So we have this debate about the merits of this legislation and whether we feel as a group of parliamentarians, as a group of elected representatives, do we think that this is a good idea to pass into the country's legislation? Having had this debate, it then goes to the committee stage. And the committee is typically a committee of 20 or so people. It's an all-party committee, so this will be people from the Conservative Party, from the Liberal Democrats, from Socialists, people from the Democratic Union Party in Ireland and the Scottish National Party, and a party called Plaid Cymru, which is the Welsh Nationalist Party. There will be people representing all of these, or most of these separate parties, and they will debate in the committee, and they'll go through this draft legislation line by line, word by word, to determine that it is clear, that it's unambiguous, that it's not in conflict with any existing legislation, it's not in conflict particularly with European legislation. And having gone through and changed and amended, what we're left with at the end of committee stage may be radically different than what started off as a Green Paper proposal, may be totally different in nature. But then the committee comes back and they report to the House and they say, we've gone through the bill, an act before it becomes part of statute is called a bill. We've gone through the bill, this is what we've decided, this is how we've changed it, And so the committee stage will then report to the House. And that gives rise then to third reading. And third reading is where the House debates and looks at these committee amendments and decides whether or not in its final form, whether or not this group of, say, 650 members of the House of Commons, whether they overall approve the bill. And once that's done, it then goes to the other House of Parliaments. Once it's gone through this procedure through the House of Commons, it then gets passed up to the House of Lords, and the House of Lords go through the same proceeding. They don't go through green paper, white paper, but they go through the same proceeding. First reading, second reading, committee stage, report stage, third reading. And if they don't like it, they pass it back to the House of Commons. And the House of Commons looks at these amendments that the House of Lords has made, and they maybe cross out those amendments and pass it back to the House of Lords again. And because it's a ping-pong game, it's a game of tennis between the House of Lords and the House of Commons. But there is a little bit of rule within the UK that says the House of Lords can only block a bill. They can only stop it from becoming an act for 1 year. So they can pass it back as often as they want, but after a year they can't do that anymore. So the House of Commons ultimately has the final say. Why should that be? Why should the House of Commons finally decide whether a bill should be passed into an act? The House of Commons is represented by parliamentarians, by members of Parliament who have been elected by the people, whereas the House of Lords, no. The House of Lords has got people who fought alongside the King in the year 1522 when we were fighting the French. And the King said, we fought so brilliantly, I'm going to make you a lord, and all your children and grandchildren and great-great-great-great-grandchildren will all inherit the title lord. So we have what are called hereditary peers. And these, a peer is another word for a lord. A peer is another word for a lord. So we have hereditary peers. And there were some 800 or so of these until very recently. And then when the socialist government took over from the conservative government, they passed law that said, we're only going to have 80 hereditary peers sitting in this upper chamber, sitting in the House of Lords. You can keep your title. You can carry on being called Lord somebody or other. You can carry on, and the title will pass down through your children and through your descendants. But you can't vote in Parliament. You're not going to be a person who helps to determine legislation. Why? Because although this man in 1522 happened to be very brave and fought alongside the King and saved the King from an arrow or a horse or an elephant or whatever, even though he was a very brave man, it doesn't mean he had any intelligence. And certainly his children, there's no guarantee that his children and grandchildren and great-great-great-great-grandchildren have any intelligence at all. And yet there they are dictating legislation in the House of Lords. So out they go. Cut them off. They can still keep their title, but they don't have any power. So the House of Lords, elected representatives, elected by the people on a regular, no more than 5-year basis, but it's typically commonly 4 years, we elect the people that we want to serve us. And it's interesting. I don't know whether you find it interesting. I do. When I was your age and younger, when I was still at school, I had a friend who lived in the same village as me, and he eventually became a member of Parliament. And I don't know, have you heard about the expenses scandal of the British members of Parliament? Yeah, where they're claiming expenses. He was claiming loan interest on a loan which he had borrowed to buy a house, which is fair enough. You can do that. And he was claiming the loan interest as part of his expenses. Unfortunately, he hadn't bought the house. Even more unfortunately, he hadn't borrowed the money. He was just claiming loan interest on a fictitious loan. And he's now, I think he's probably still in prison, my elected representative, my member of Parliament, my friend from years ago. I even went to his mother's marriage, a second marriage. I went to his mother's marriage because otherwise it was going to be full of old people. And so this friend of mine said, do you want to come along? And he's there doing his time in prison at the moment. Though you elect who you think is good. And there's one country I'm thinking of in the Baltic states, I think, where they have elected recently a president who's alleged to have taken money to perform operations, allegedly, but I can't remember which country it happens to be. So you elect the people that you think are going to serve best, and I think in that particular case, this alleged, dare I say, corrupt president was probably the better of the two choices. Maybe, but I don't know. So we've gone through blah, 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 blah. Third reading, the House of Commons has the final say. Another tiny point, the House of Lords, the upper chamber, is not able to amend what are called treasury bills. I think I'm right on this. They can't amend the bill which is creating the tax structure, the tax system. So they can't change treasury bills. But they can amend others, but they can only do it for a year. Fox hunting, the bill on fox hunting was a good example, where the House of Commons under the socialist government said fox hunting is inhumane, it's bad news, it's killing these wild, lovely-looking creatures, and silly men and women sitting on the backs of horses follow a man with a trumpet and a pack of dogs, and they hunt foxes out in the countryside and kill them for sport. And the fox, they say, the fox enjoys it. As you would, wouldn't you? You're being chased by these 50 dogs and men in red jackets and silly things. And so the Socialist Party said, this is not good. We're going to create a piece of legislation, an act. We're going to pass an act which bans fox hunting. And the Conservatives said, no, this is wrong. That actually, fox hunting is a good idea. And if you think about it, if you think just a little bit outside the box, you might actually agree. Because they don't catch every fox they chase after. They only catch something like 1 in 20. And the ones that they do catch tend to be the older ones and the ones which are ill or lame or can't run fast. And therefore it's actually improving the quality of the fox population by getting rid of the old ones, by getting rid of the ones who are ill, the sick ones who can't run fast enough to escape from the dogs. It does improve the fox population. It improves the quality of these rare animals, not rare, these wild animals. So I'm in favour of fox hunting. I think fox hunting is an excellent idea. And the fox enjoys it. It went up to the House of Lords. They said no, passed it back. It went again. They passed it back. It went again. And it went on for a year. And eventually the year elapsed and the House of Commons said, right, enough. Pass this bill now to the Queen. The Queen will sign it. She may be in favour of fox hunting, but she still signs it because although she's the head of state, she's really administrative. She's really a figurehead rather than a ruler. She's not Mrs. Gaddafi, for instance, or Mrs. Mubarak. The same proceeding then in the other house. Then it goes to royal assent, and then this bill becomes part of the law of the country. And it applies to the entire country. There are bits and pieces of the country which are subject to their own local legislation. For instance, the law of property in Scotland is rather different from the law of property in the UK, in England and Wales. But because property law is not in your syllabus, I'm not going to go any further. But that's why this paper is called English law. It's not called UK law. It's UK taxation, but it's English law because it's different from Scottish law. Okay. And can I remind you again, John asked me specifically to bring this to your attention, when you are entering for your exams, some of your firms do it for you automatically, others of you do it for yourselves. Make sure you enter for the English variant of the F4 paper. I can't help you tremendously. I can help you a bit with global law, but I can't help you as well as I could with English law. So English law is the one that we're doing. We've gone through this process of introducing an idea and then developing the idea and debating it and committee stage, report stage, third reading, onto the other house, back again, back again, back again. We've gone through this procedure. And at the committee stage, the committee's gone through the bill on a line-by-line, word-by-word basis in order to eliminate inconsistencies, vaguenesses, ambiguities, But even so, they still do come through. They still arise, that a situation 20 years later arises and you go and look at the act, and the act actually can be interpreted in two different ways. So the courts, the judges, are given rules of interpretation, and that's what we've got on page 12. There are rules and there are presumptions. A presumption is something which is assumed to be correct. A presumption, it's assumed to be correct unless you can show otherwise. That's what a presumption is. A presumption is something assumed to be correct, but you may be able to show otherwise. A presumption assumed to be correct unless proved otherwise. And to prove it otherwise, there's a special verb used to show that a presumption is not correct. To say that although normally you might expect that this is so, I can show that it's not in this particular situation. And the verb to show that a presumption is not correct is the verb to rebut. To rebut. And therefore the adjective on rebut is rebuttable. And it becomes then a rebuttable presumption. And we've got presumptions on page 13. But I want to look at the statutory interpretation rules first of all. These are rules which govern judges when they're faced with the problem of interpreting the words within a statute. And the first rule that they follow is the literal rule. And the literal rule says that a word in a statute should be given its ordinary everyday meaning. Where do you find the ordinary everyday meaning of a word? In a dictionary. Yeah, so you look up, not just any old dictionary, it's the Oxford English Dictionary. But if you need to know exactly what a word means, you look it up, or the judges would look it up in the Oxford English Dictionary. But we have a little bit of a problem there, because you know very well that some of our words in English have more than one meaning. So, for instance, the word lead. That's an easy one, isn't it? The word lead may be the metal, or it may be the verb to lead. Some words are actually homophonic. That is, they sound the same, but they mean different things. The word contain means to hold within. A bottle contains water, but it also means 180 degrees opposite. It also means to hold without. So if you contain the enemy, you keep the enemy away from your town. So a word just like that can have two completely opposite meanings. The word set in the UK, the word set, if you look it up in your dictionary, I think I'm right, I may be wrong by 2 or 3, but I think there are 170-something different meanings for the word set, or different interpretations. So a judge, when facing the literal rule, has got to interpret words in a statute according to their ordinary everyday meaning as defined by the dictionary, but the dictionary gives you 170 different alternatives. The word awful. The word awful. If somebody describes something as awful, is that good or bad? Bad, isn't it? Yeah. But when the king was riding along in a carriage with Sir Christopher Wren, who designed St. Paul's Cathedral and oversaw the construction of St. Paul's Cathedral, when it's finished, it's got a royal event, and the king is in his horse-drawn carriage, and they turn around the corner in the street, I think it's probably Pall Mall, they turn around the corner in the street, and there is St. Paul's Cathedral in front of them. Fantastic. And the king turned to this architect, Sir Christopher Wren, and said, Sir Christopher, that is awful. Now, would you be happy about that? The king has just told you a major work of construction which has taken 20 years, and he just says it's awful. Well, in the time that he was using those words, the word awe means wonder. I am in awe of the quality of English of overseas accountancy students. I wonder, I'm so fascinated and impressed. And that's what awe means. It's not commonly used these days. So if it's awful, I am full of awe. I am full of wonder. And the E gets dropped out of it and it becomes awful, and it means something completely different. It's awful. So words in a statute are given their ordinary everyday meaning. But the meaning of words changes over a period of time, as in the case of awful. Or it develops, as in the case of the word set. Originally, set was just one thing. It was a set of cards, or 6 games in a game of tennis. So many different interpretations, and they do develop, and it's a living language. There are some languages, I'm thinking particularly of one over in what used to be part of the USSR, a country up in the northeast of Europe, and they are heavily protective of their language, and nothing can change. And when the Polish president was killed in an air accident, they wanted to name a street in honor of the Polish president, and the Poles said, that's excellent, but can we have the street written in our own Polish characters? And they said, oh, no, you can't do that. It's got to be written in our characters. And so this same country I'm thinking of, when the American president, the former American president, visited, there's a plaque on the town hall, and it says, to commemorate the visit of Georgius Bushus. He's not called Georgius Bushus, he's called George Bush, but they changed his name to put it into their local language. How can you do that? You can't change your name to Sandros, can you? Anyway, that's the literal rule, given their ordinary everyday meaning, unless ... and so the next rule follows immediately on from the literal rule, and that's the golden rule. And the golden rule says if the literal rule leads to an absurdity, to something which is absurd, then we will ignore the literal rule. We will ignore the words within the act, and we will apply common sense. So golden rule is where the literal rule leads to an absurdity. And we've got here our first cases, which you should know. Ideally, you will learn these case names. It's going to be exceedingly difficult for you, I know that. So what I've tried to do is at the end of the notes, on pages 123 through to 134, I've got separate lists. So you'll see on page 123, you'll see that these are cases where the plaintiff and the defendant have got the same name. So it's a family matter. Maybe husband and wife, maybe two brothers, brother and sister, maybe grandfather, granddaughter. So they have the same name. And that was the common element about them. They're in completely different areas of law. Some of them are in the same, Balfour, Merritt, Spellman. They're in the same area of law. But otherwise they're not. They're all over the syllabus, all over contract law, company law. And it's a way in which you can begin to help to remember what's involved with these cases. There are other lists going on. We've got horses and directions and colours and cars and ships and Christian names or forenames. So it's a way in which you can bring together cases from across the syllabus, and it's in a quick and easy way of remembering them. And you've got two columns here, the area of law and the principle. The area of law might be, for instance, contract law, breach of contract, or uncertainty in contract words. It could be only 2 or 3 words I won't expect you to put into the area of law. And then in the principle, it would be very sensible if you could maybe summarize what I will be telling you into, say, 25 words, and just put them down there as a summary of salient, of important matters, and things to help you remember the details. If you do that, and then on the way into work, you can fold your paper over like that, or even at home of an evening, when the adverts are on the television, or get your husband or wife or loved one to just read through, and they will read the case name, and you say, oh, that's in contract law, it's about breach of contract. And it will help you to remember them. You can get through them quickly, and after you've been through them 3-4 times, you will be amazed at how much you do remember. So it will add to the quality of your answers if you're able to say, silence cannot be acceptance, brackets, Feldhaus and Bindley, That's all you need, right? There's no need to say, in this case, the nephew left his horse with the auctioneer or with the uncle to look after and the auctioneer falsely sold it. You don't need to go into that detail. All you need is silence cannot be acceptance and quote the case name. But if you can't remember the case name, then you have to say silence cannot be acceptance. There is a case involving a man who left his horse with his uncle and the auctioneer wrongly sold it when the young nephew went abroad. Blah, 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 blah. All you need is the case name. So it saves time, it's definitive, it's professional, and that will be ideal. But I know students who've passed the law exam without quoting a single case name. It's not the end of the world. You come out of that exam in 2 months' time, and you say, oh, I didn't put a single case name down. It's not the end of the world. You can still pass the exam. Look at the marking schemes and the exam questions, and you'll see that the examiner's marking scheme says 8 to 10 marks, a good understanding of the topic, case names or illustrations will typically be given. So he's looking for that definitive, that authoritative element. So we've got these first cases in Golden Rule. We've got Sigsworth and Whiteley Chapel. And I'll look at page 125. Whiteley Chapel is the first colour case. Whiteley and Chapel is the first colour case. So you could put in there area of law, statutory interpretation rules. And then when I tell you the story about Whiteley and Chapel, then you can summarise it into just a few words. Illustration of the Golden Rule. Something else I need to tell you about these case names. There are 3 types, 3 ways in which a case may be identified or may be referred to. The most common one is this Whiteley and Chapel. But there are 2 other ways, and we've already got one of them above. We've got re Sigsworth. That's called a re case. And there is a third possibility, and that's an R case. R and Clark. So we've got the 3 possibilities of how we refer to cases. This V that you see in Whiteley Chapel, this has never been asked. It's never come up in an exam question. But it's interesting because most people and most of your acquaintances, if they see the V, they know instantly what the V means. What does the V mean, Madra? What does the V mean? What does the V mean, Julia? Mara? No? Anyone V? Versus is a good answer, but it's not right. It's not, in fact, right. Versus will be VS. This is not a prize fight. This is not a boxing match. This is 2 people in court, Whiteley and. It's an and sign. It's Whiteley and Chapel. And the reason it's a V is because not many people can draw an ampersand. So people, often when they're drawing an ampersand, they'll do that. And if you do that in handwriting, if you do that quickly, it becomes that. And if you give that to a typist, they type V. So it's actually a distorted ampersand. It's an and. So it's always Whiteley and Chapel. I will be consistent on this, and I have been for years. I never refer to cases as Whiteley versus. It's always Whiteley and. Okay? Sigsworth, the re case. The re case is a one-sided case. So we don't have plaintiff and defendant. We have someone going to court to ask the court's advice. These are often people in a representative capacity. So they may be a liquidator, they may be a receiver, they may be an administrator or an executor, or they're someone who's looking for the advice of the court. Because if they do something wrong, that will typically involve them in personal liability to compensate the one who has suffered. So if I'm distributing an estate and I wrongly distribute it evenly, but when challenged, I should in fact have sent 50% of the estate to one person and then distributed the rest. This one who's lost out and should have received 50% can sue me and say, I want the money. Now, you may think I can go back to you because I've overpaid you. But in fact, I can't. If I have paid you wrongly too much money, I can't recover it from you. Therefore, I have to compensate the loser out of my own pocket. So if there's an area of ambiguity or vagueness or absurdity within the interpretation of a law, these representatives, these legal representatives, are able to go to the court and ask the court's advice. And then, having taken the advice of the court, I'm then able to make the distribution. If subsequently, on a later case, the House of Lords determines, or the Supreme Court determines, that the earlier decision was wrong, I am still protected, so long as I've distributed the estate according to that legal judicial advice. So that's what a re-case is. It's a one-sided case where somebody goes to the court looking for an interlocutory decision. An interlocutory decision, asking the court for advice. I honestly do not see you writing the word interlocutory in your exam. Unless your examiner says, what's the significance of re in the case re Sigsworth, then you would write the word interlocutory. Otherwise, I don't see it being applicable. And this final one is R. Now, I've already mentioned a person who is R. I've already mentioned a person who is represented by the letter R, and therefore you should be able to guess. Think of Freddie Mercury. Queen, yeah, it's the Queen. The Queen is called R. When she came over here and visited you, she signed your visitor's book as Elizabeth R. And R is the abbreviated, accepted abbreviation for the Latin for Queen, which is Regina. And when she, heaven forbid, but she will eventually, when she dies and Charles becomes king, is he going to be called Charles Regina? No, he's going to be called Charles Rex, and therefore the abbreviation R is applicable to the monarch of whatever gender. Rex, then, the Latin for king, Regina, the Latin for queen. And these are cases, this is not the Queen taking Superman to court. This is not the Queen taking Clark Kent to court. This is a case of such major importance that it's being brought, the plaintiff is being brought in the name of the monarch. I said earlier that criminal cases are brought in the name of the local chief policeman. If it's a really important case, it's going to be brought in the name of the monarch. And that's what this one was.